Okay, so let's continue. Would we need a break in between? Because I was told that there would not be a break, so I thought. Not required? Great. It just wastes time here. Right to privacy. Very famous Putta Swami judgment. Right to health. Right against solitary confinement. Shatrughan Chauhan case. Right against handcuffing. Prem Shankar Shukla. All these rights. Minka Gandhi case. Right to travel abroad. What else? Right to information. This is one more source of RTI. Right to reputation. Defamation law is justified on this ground. Criminal defamation. Okay. Right to marriage. Right to marry somebody of your choice. As we have discussed earlier, they should also want to marry you. This is very important. Okay. It is mutual. You can't claim I have a right to marry you and marry somebody. No. So, convince them, confuse them, trap them, then it's okay. Also, right to marry is subject to Indian laws. Okay? Sorry?
Special Marriage Act.
Various laws. Special Marriage Act is one such law for logical people, for non-religious people. I do not mean that, sorry. No attack on people who are believers. I want to live also. I have a batch to finish, so. The point is that what I meant to say was subject to Indian laws, meaning you can't claim right to marry somebody of the same gender, because in India we don't allow that. Okay, in some other countries it is okay. Anyway, we might make fun, etc., but homosexuality is perfectly normal. There is nothing wrong in this. It's just a sexual orientation. That's it, right? So, but we don't allow for this. In 2018, it was decriminalized, meaning now homosexuality is not a crime. Section 377 was diluted, or should I say, read down. Section 377 of IPC says that any kind of unnatural sexual activity involving adults, animals, or children is a criminal offense. So in 2018, that consenting adults thing was removed from there. Section still remains. Any kind of activity involving animals and children, bestiality and pedophilia, that is not allowed. Because animals can't give consent, children under 18 can't give consent. Okay, but consenting adults, no problem. So there is no concern with respect to sexual activity. Marriage we are yet to allow. Okay, that is why you can't claim right to marry somebody of the same gender under Article 21, because this right is subjected to Indian laws. Whatever laws allow, within that you can. Okay, so you can marry somebody of a different caste or religion, depending on your survival also. If you want to live, maybe, we don't know. Then right to freedom from noise pollution, right against sexual harassment, all these. This was recently in 2021, Mudrika Singh judgment. So all these are various interpretations of Article 21. Article 21 is a crazy article because people go to court to claim this. This article does not include right to die. Passive. Specific conditions. List of conditions. Common cause case. So passive euthanasia is not the right to die. It is a right to die with dignity. That is important. Article 19(1)(a), speech and expression. Right to speak, exact opposite. Right to remain silent. Both are there. Yes or no? Right to live, exact opposite. Right to die, that is not there. You can't die like this. You can't give up on life. That is why till 2017, committing suicide was a criminal offense. If you commit suicide and you survive because of the poor quality of poison, because it is India, you'll be jailed for up to 1 year. In 2017, we had the Mental Health Care Act, wherein it was said that if somebody is committing suicide, they are not wired properly at this point of time. They are suffering from some mental issue. They have taken that extreme step. You can't reverse death, right? And there is no magical place full of great things, and I don't know what all things are being told about heaven. You can talk to the religious people; they'll explain to you what is there in heaven. Rivers of wine and whiskey, and greatest of food. You eat and you will never get fat, right? One single song you play runs for 78 hours. I'm not saying this. Religious people are saying all these things on social media. Such beautiful place called heaven. So you die and it's the end of life for the person. So the point was that if you commit suicide and you survive, you have to firstly be mentally evaluated. If the doctors find you mentally fit, only then can punishment be imposed on you. Are they clear? So this is there, but yes, passive euthanasia. You know euthanasia? When somebody is suffering, they are in a permanent vegetative state and they depend on external life support, then under specific conditions, you can be allowed to die. Right to die with dignity. Okay? And as for other things like say active euthanasia or maybe Sanlekhna, the Jain practice of Sanlekhna, it is pending in court right now. Okay? Matter was challenged in court in 2015 Nikhil Soni case. High Court said Sanlekhna is banned. Supreme Court put a stay order on the judgment. So the matter is pending in court. Okay? So whether Sanlekhna is allowed or not, right now there is no clarity on it. People are still doing it. That's a religious practice. But currently the matter is pending in the court. And courts know very well. There is no correct judgment here. Because when it comes to religion versus logic, you know very well what prevails. Life prevails. So, religion prevails.
So the right to free legal aid is mentioned in fundamental rights.
Which right? Right to freely?
Free legal aid.
Right to free legal aid.
Then why High Court and Supreme Court is charging him this? And moreover, it is also mentioned in DPSP, Article 39.
Firstly, DPSP is not enforceable. But point is correct. We have something called NALSA. Approach them. But you don't pay the money, right? Approach them. They'll pay the fees on your behalf based on conditions. But you want the best of lawyer. Harish Salve, you have to pay his fees. Or else we'll give you this kind of lawyer only. And they're also nice lawyers here, don't worry. But if you want free service, it comes at a compromise. You want Kapil Sibal, then pay 25 lakh rupees per day of hearing. That's his case fees. 25 lakhs for 1 day of hearing, one case. If you want to consult him or a phone call for 1 hour, 11 lakh rupees is a consult. Don't change your profession right now, but that's how it is. Okay, so you have the option available. See, if you think like this, second one, right to decent environment, it is being violated for people of Delhi on a daily basis. Yes or no? Right against bonded labor, it is being violated for you also on a daily basis. Forced to bring vegetables from market in the house. Forced to fill the fridge with water bottles now. Summertime is coming. Bonded labor, forced labor. Tell you in your family, no violation of Article 21 will be tolerated. They might slap you and all, but polity wins. Okay, 21A, very simple. Kids between 6 to 14 have to be sent to school because currently there is no social media influencer course. So you have to go to school only. And this was added through the 86th Amendment Act. And in pursuance of this, we have made a law also called RTE, Right of Children to Free and Compulsory Education. Article 21, capital A, Amendment Act, remember this? This Amendment Act has made 3 changes. 1, a new article was added. Number 2, DPSP Article 45 has been modified. Number 3, one fundamental duty has also been added. Okay. This is the right, you know the DPSP 45, which now says that kids between or under 6 years, the state should try to provide for ECCE, Early Childhood Care and Education. Underline this. All those, LKG, PKG, TKG, play school nonsense. ECC. It happens in private sector. You have all these kids at 1 or 2 years old, only parents are throwing them to school, let go, become IAS immediately. So we want this to be in the government school also. Make the kids suffer right from the age of 1 or 2 only. Okay, spoil their life completely. So that's it. Duty, it is not meant for you, don't worry. It is meant for citizen who is the parent or guardian. If you are parent guardian, then of course. If not, then not meant for you. So if your kid is between 6 to 14, please send him to school. Don't make him work in the house. Article 22. If you are arrested, you enjoy 3 types of rights. Right to be informed of ground of arrest. The next time police comes to arrest you, ask them, why are you arresting me? They might beat you. But polity wins. Right? Second thing, right to consult legal practitioner. Meaning, in these Hollywood movies, they'll say, I'll talk to my lawyer only. In India also it is allowed. So don't next time call your friend, call a lawyer. What will a friend do? Lawyer will help you. So tell the police, I'll talk to my lawyer only. And they have to get a lawyer for you. No, police will not obstruct with a lawyer. Lawyers are dangerous people. So the only people police are afraid of are judges and lawyers. Okay. And only people judges are afraid of are lawyers. So be a lawyer. Harass everyone. They can simply file a court case against you. They are going to court every day. Your life becomes hell. Even judges sometimes are afraid of lawyers in the lawyer lobby. I am referring to judges of high court. Not the lower courts. Forget lower courts. High courts also. Then when the police arrests you, they have to take you to court within 24 hours. That is why arrest on Friday evening. Saturday, Sunday court is closed. Friday evening arrest the person, go to judge's house, get an approval. In most cases, judge will give the approval that okay, bring him on Monday. But that approval is required. There is a misconception that you arrest somebody on Friday and nothing is required. No. If you arrest them on Friday evening after the court time, you have to get the approval of magistrate. But it is given in 99.99% cases. So if you want to truly harass somebody, arrest them on Friday evening. So 2 days in police lockup is sufficient to treat them properly. Take out all your anger against them in 2 days. Not visible, okay? It should not be on visible places because there will be a problem. So these 3 are the rights available to everyone. But not to 2 categories of people. One is enemy alien. Who are enemy alien? Who is alien? Not Jadoo. Foreigners. Who are enemy aliens? Pakistani citizens are enemy aliens, yes or no? Chinese citizens? Then currently who is enemy alien of India?
Pakistan and China are enemy alien.
No, don't fight. Right to express views. Then how do we define enemy alien? Very good. The criteria is that people or citizens of those countries with which India is currently engaged in a war. Right now, we are not at war with any country. So we do not have any enemy alien. But when you are at war, official declaration of war, not in your mind and heart, official declaration of war, the people become enemy aliens. Clear? So nobody is an enemy alien right now. Enemy aliens can't get these kind of benefits or people arrested under PDL, Preventive Detention Law. Preventive detention. Detaining people before a crime has been committed. First point. Okay. So to prevent you from committing a crime, we arrest you. It can be done by both center and states. Why? Because preventive detention is under union list as well as concurrent list, not state list. That was a trap. So don't feel bad. It's okay. So union list and concurrent list. On what ground can you arrest people? Security of the state, maintenance of public order, maintaining supply of essential services and foreign affairs. All clear? Okay, great. Then, now, once the police arrests you to prevent you from committing a crime, they will arrest you and keep you for how many days? Up to 3 months they can. Now, in this time duration, they will take you to a judicial advisory board. That judicial advisory board comprises of people who are or who were or who are eligible to be a high court judge. What is the qualification to be a high court judge? 10 years? Advocate, where? In high court. Okay. What else? Okay, don't worry. We'll come to that under courts. The other qualification is 10 years of judicial service or judicial officer, meaning lower court judge for 10 years. So, this is the preventive detention. We have various such laws like the National Security Act, okay, COFE POSA, Conservation of Foreign Exchange and Prevention of Smuggling Activities, POTA, the bill which was passed after the parliamentary attack. POTA, POTA. It was one of the examples of which kind of bill? A bill passed under joint sitting. We have had only 3 such examples of joint sittings, one of which is the POTA also. One more example. No. Dowry Prohibition. Dowry Prohibition Act of 61 and the Banking Services Commission repeal. 3 examples of joint sitting. Okay. Clear on this? Doubt? Article 22. So this is a right given and then some restrictions also. One more thing, people under preventive detention, they are allowed to vote. No, people in jail, not allowed to vote. You are aware of this? If you are in the lawful custody of police, you can't vote. I am not saying convicts, I am saying accused also. If you are inside jail or police lockup, you can't vote. Okay. But if you are under police custody for preventive detention law, police has to make avenues for you to vote. Clear? More on that later on. Let's move on quickly. Next 2 rights, rights against exploitation. So Article 23 says that now all kinds of nonsensical things like traffic in human beings. Traffic in human beings means what? Buying and selling of human beings like goods and commodities. Immoral traffic in women and children is not allowed. Devdasis, you know Devdasis? Okay, not allowed. Slaver? No, slavery. Not allowed. Devdasis, you must have read that Raja Ram Mohan Roy worked to eradicate Devdasis and Sati practices. Yes or no? What data? We don't know. Where is the data? Was Sati wrong? Of course it was wrong. Was it being practiced rampantly in the country? There is no data. Before 1813, there was no data on this. It was being practiced. Remote areas, 1 in a million cases. Suddenly after 1813, all the government reports started saying that Sati is being practiced heavily in India. Why? Why after 1813? What happened in Charter Act? What was allowed? Yes, that's the reason. Charter Act of 1813 allowed the entry of missionaries in India. And there are adequate government reports to support that. You will see post 1813 or 1809 actually, the reports started getting published of increased cases of Sati reportings. Before that, no document mentions this. But if something is so rampant, it would mention other records also. No mention of this in other records, except after the 19th century beginning. So, we don't know. Raja Rammohn Roy, I'm sure, great human being definitely. But the allegations of him working in cahoots with the British. Because Raja Rammohn Roy got a lot of support from Britishers, including pension. There were other people also. Ishu Chandra Vidyasagar, he never got the support from Britishers. He was also working towards widow remarriage. He was facing a lot of problem with the Britishers. He was facing a lot of concerns. The entire Arya Samaj movement, they faced concerns. Why was he getting so much of support? Not my view. I'm just giving you the other point of view. Anyway, so these things are there, not allowed. If you practice any of these things, we'll punish you with a law. 2 laws are there. Number 1, BLA, Bonded Labor System Abolition Act. This law is also mentioned under Schedule 9. Schedule 9? Schedule 9, not Part 9. Immunity from judicial review. Remember, Schedule 9. Okay. The other law is called ITPA, Immoral Traffic Prevention Act. Actually, this law was called Suppression of Immoral Traffic Act. It was renamed. Why? Abbreviation. Check the abbreviation. That is why it was renamed. Because the abbreviation was after a Hindu goddess. So they had to rename the law. Call it ITPA, Immoral Traffic Prevention Act. Clear? So, traffic in human beings, begar. What is begar? As I said, compulsory work without remuneration. If your parents are telling you fill the fridge with water bottles, that is called begar. It is not allowed. Okay? But what is forced labor? They are sending you here to study. Forced labor. Difference. Okay? That is also not allowed. You can refuse, but you have to get money also. Stay in the home also. That's a problem. So, begar and forced labor will not be allowed. Difference is begar, you get no money. Forced labor, you are working against will. You might get money. And don't claim that, sir, companies are making us sign bond and all. That is not forced labor. You are signing the bond out of choice. Okay? If you don't want, don't sign the bond. Now, the interesting point is second clause. Even though forced labor is not allowed, the state can impose, underline this very important provision, state can impose compulsory service for public purposes. So, your parents cannot impose forced labor, but state can. Look at the importance of state. State is now more important than parents. That's hilarious. So, any example of state imposing compulsory service?
Military services.
Cricket stadium? Cricket match. So I don't understand the example. Ball boys. That is not compulsory service by state. No. Election duty. Election duty is enforced. You can't refuse. Or in future, we can have conscription, as you guys said, military service. A lot of countries impose it, right? Algeria, Cuba, Israel, that actress Gal Gadot, Wonder Woman. Have you seen the Wonder Woman? That actress Gal Gadot was actually a part of Israeli forces. South Korea, all these BTS people, that is why women were very upset there. Don't send BTS to, Indian people were protesting. Don't send BTS to military service and all. I think we need to calm down a bit. But when you impose any kind of compulsory service, you cannot discriminate on the basis of religion, race, caste or class. Underline these 4 terms, important. So, let's say India says, come on, you have to fight. Can we ask only Hindus to fight? Only Muslims to fight? Not possible. Can we ask only rich or poor to fight? Class? Not possible. Caste? Not possible. Can we ask only men to fight? That's possible. Okay? So, only men, only women, it is possible. Be aware, bhai. Don't tell me you are not warned. You are warned. One important point. It is meant to impose compulsory service for public purpose only. Okay? So, the government cannot tell you, come and clean my house. It is urgent. But my point is, let's say you... This is actually a restriction on your rights, yes or no? Let's say you are going for an interview. You have cleared the prelims somehow, cleared the mains also somehow, and then you are wearing your best of clothes, dressed up properly, taken bath after 3-4 months finally, and you are going for the interview. A police constable stops you and says, where are you going? You are in full attitude. You say, don't disturb me, or else I'll transfer you if I become IPS officer. And then he asks, okay, interview for UPSC. So he says, can you see the drain on the side? You say, yes, the drain is clogged. Please clean it. Public purpose. Drain. I am imposing state. Police is part of state. Ajay Hasia case. They are imposing compulsory service for public purpose. Can the police officer give this order? Why? Don't say, why will he's an emotional human being. No. I want logical reason. No is correct. But why? The police is an official. What he is issuing is an official order only. This is a restriction. Restrictions are imposed through what? Laws. The police is giving you an executive order. You will ask him, show me the law. If there is a law which authorizes the police to give such orders, you will have to follow. As of now, there is no such law. Don't worry. Okay? And this won't happen also. I mean, not that he won't clear the exam. That will happen. Police will not stop you. Don't worry. Done? Next is 24. Let's move quickly to 24 now. Wait. Before you come to 24 and before you read that, answer is simple. 24 is preventing child labor. My question to you is, can you employ kids under 14 as... So because the article 24 says that children will not be employed in factories, etc. My question is, can you employ kids under 14 as household help, domestic servant? Yes? Very good. Excellent. It is banned for the last 20 years. If you are employing, please don't. It has been banned since the last 20 years. Excellent. Then I'm sure you're employing. If somebody is employing, please don't. Okay, let's come to it. I'll explain to you that also. No child below the age of 14 years shall be employed to work in any factory or minor engage in any other hazardous employment. For that, they made a law called Child Labor Regulation and Prohibition Act. Initially, this law banned kids from working in 18 occupations. In 2006, the ban was extended not to be employed as domestic help, roadside dhabas, tea stalls, spas, hotels, etc. And 2016 onwards, kids under 14 cannot be employed anywhere. Okay? Nowhere except two places. Family run enterprise. That also after school hours. If your parents are running some vegetable shop, etc., then the kid can give helping hand. Clear? It should not impact their studies. Fixed limited hours only. And number two, which is required, audio visual entertainment industry. All these shows and programs, dance junior, jump senior, whatever the names are, there you have to employ kids. Because kids bring TRP. They'll cry, I come from poor family, etc. TRP, viewership increases. How else will you teach kids to waste their life? So these two only. Clear? If you employ kids, then it's of course punishable. 6 months of punishment, 20,000 rupees of fine. It can go up to 2 years of jail and up to 50,000 rupees of fine for repeat offenders. 20,000 fine per child employed. Okay? And it does not mean that once you pay the fine, you can keep on employing the child. No, this is not some payment to employ the child. Employment has to stop. In 2016, one more category was created called adolescent, 14 to 18 years. Anybody under 18 here? No. Okay. So they are called adolescent. These kids will not be employed in hazardous occupations. What is meant by that? 3 things: mines, explosives and inflammables. These 3 sectors are called hazardous sectors. Bangle making, matchstick making, coke industry, iron ore industry, all these things. Mines, explosives and inflammables. Your rights knowledge is slightly limited. This is an area where normal UPSC aspirants have more knowledge. Anyway. So the point here is that this is the law to prevent any kind of child labor. Now I think we know very well, under 14, zero employment. Anywhere, standard practice. Now, of course, please don't claim that, sir, I saw some kid working in a dhaba, etc. Okay, that is wrong. Go and complain. Go and complain. Don't take action on your own. You are not the law enforcement agency. No, I have to warn because after reading this, people get excited. Okay, I'll complain. This is a true story. Around 6-7 years back, this happened to a student. The student came and said, sir, you had said this. And because that I took an action. So what happened? The student was going somewhere and in an auto, at the signal you have kids begging. So one kid came asking for money. The student, she said, oh, who is forcing you to beg, etc. I'll take you to the police, don't worry. As soon as she said police, the kids became nervous. He started shouting, kidnapping, kidnapping. And all the people got around and questioned this student that what are you doing, taking this kid home to force him to work, etc. There's a huge problem. Then she showed I'm a UPSC aspirant, she sees these books and all. So people did not beat her. Plus she was a woman, maybe that's also a reason. If it was a guy, thrashing proper. So please don't take these risks. You are not the police. Complain. Go to the Ministry of Women's website, pencil, that is a subsection, complain there. Take a photograph, submit to the SP office, etc. Don't take action. Okay. Kids are involved. You never know what happens. Anything can go wrong. Clear? Okay. Well, sometimes unknowingly we might end up in trouble. So this happened to me once that I had gone to meet somebody in the hospital. That is in a very remote kind of, not remote area. Near the hospital, you don't have nice shops. There's only one hospital canteen and one shop which was selling biscuits and all these things. So I purchased a packet of biscuit. I ate one. I thought this is rubbish. I did not eat it. So I was just walking. I was trying to find a place to throw it. I saw a kid coming in a school dress. I just said, okay, take this, I eat it. And then the kid saw me and ran with full speed shouting. Now imagine the kid has been told this by his parents. There will be a guy who will come, who will offer you biscuits. I think maybe that's when I realized, oh, I should not have offered biscuits to a kid like this. So sometimes, honest mistakes can happen. So please. Anyway, next 4 rights, dangerous rights, freedom of religion, 25-28. This right is meant for individuals. You know very well you have 4 types of rights here. Freedom of conscience, profession, practice and propagation. Conscience meaning what? You have full freedom to mold your relationship with God. You talk to God, God comes in your dreams. God is in parents, God is in books, it's your choice. God is in somebody you love, tujh mein rab dikhta hai type. It is your personal problem. Nobody cares. Clear? Right to profess meaning proclaim your religion. There are various ways to profess your religion. For example, a Hindu can wear a tika, Muslim can wear a cap, a Sikh wears a turban. Those are a part of professing your religion. Clear? In the constitution, only one thing is mentioned very clearly. Wearing and carrying of kirpans. Kirpan is a knife. By the Sikh people is a part of professing their religion. So Sikh people can carry a kirpan, it is allowed. Of course, they won't carry a full machete somewhere. They have a symbolic plastic knife that they carry everywhere. That is allowed. You can't raise concerns about that. Can a Hindu wear a tika? We don't know. It depends on interpretation. Can the Muslim wear a hijab? We don't know. It depends on interpretation. Other things are not mentioned. Only one thing is mentioned. Clear? So if you want to claim that wearing a tika or a hijab, etc. is my right to practice religion, we'll have to check it through your texts. Is it mentioned or not? Are you clear? Then, right to practice your rituals. That's also there. Practice all your drama. Nobody cares. But let me remind you very importantly, let's read the article, clause 1. Read it. What is mentioned? Subject to? Exactly. Public order, morality, health, and other provisions of this part. Which part? Which part are we studying right now? Part 3. So, public order, morality, health and all other provisions of Part 3 are a restriction on freedom of religion. Are we clear? That is why freedom of religion is the lowest in the hierarchy of rights. If you want to arrange the rights in some hierarchy, this is the last right actually. Because every other provision is a restriction on this right. That is why people never go to court to claim Article 25. They always claim something else. To give you a simple example, wearing a hijab, right? There was an issue in Karnataka and that's how the matter is pending in court right now, Supreme Court. The school did not allow entry of these kids wearing a hijab, claiming that Article 19, 1G, the right to practice my profession, occupation, trade, business. We saw that today. Okay. Now, what did the other group, the Muslim group, what are they claiming? They can't claim Article 25 because the problem is Article 19 is a limitation on Article 25. So, they are also claiming Article 19 only. But Clause 1, Subclause A, the freedom of expression. Wearing a hijab is my expression. And they've also added Article 21, wearing a hijab is my dignity. So, it is not a religious issue. See how the court system works. Okay. For example, I mentioned the Sanlekhna, gents. The matter is pending in court. Why? Because people who have opposed Sanlekhna, they are claiming that these people are dying. They are violating Article 21. Now, people who are claiming Sanlekhna as a practice, they can't claim Article 25. Because then the war is between 21 and 25. Which right wins? So, they are claiming right to die with dignity. This life is not worth living. I am trampling on insects on a daily basis, right? I am causing suffering, etc. I want to end my suffering. I have a right to die with dignity. So, both are claiming Article 21 only. Different interpretation. Is the point clear? You never go to court and claim this article. You always try to claim some other article for purely legal purposes. That is why this right is the least in terms of hierarchy. But for people, this is the highest. Okay. And the fourth one, right to propagate. Propagate means market your religion. Spread the doctrines. Right to propagate does not include right to convert. If conversion is obtained through force, fraud or allurement, if you try to convert people through these three means, not allowed. 1977, Father Stanislaus case, you can't use force, beat somebody, maybe. Fraud, how would fraud be? Maybe pretext of marriage, etc. Allurement, money, or join my gang, you will clear UPSC. That's also possible. Like how you are wearing all the rings and magical things, doing some rituals to clear UPSC. Everything except answer writing. So, follow the rituals, but also study. That is actually more important, right? So, this is the right that we have. And I think while discussing preamble, I mentioned this term that Indian secularism. What does it mean? Principled distance or intervention. State can interfere in religion. Come to clause 2. It says, nothing in this article shall affect the operation of any law or prevent the state from making a law. This means that this article cannot stop. The state has full right to make a law. For what? Regulating or restricting any economic, financial, political or other secular activity. Let's say a religious group is running some school or college or a hospital. Now, they can't claim that only a Maulvi or a Pujari will conduct open heart surgery there. That is not possible. If it's a hospital, it has to follow government norms. Clear? And extremely important, this is what is Indian secularism. Providing for social welfare and reform. This is what the state can provide for. If your ritual is violating somebody's dignity, to provide for welfare and reform, we can interfere in your practice and cancel that practice. Are you clear? This is called Indian secularism. This is a source. Welfare. In the Western countries, they don't provide for welfare. They say it is your personal problem. We can't interfere. But here we interfere. Or throwing open of Hindu religious institutions to all classes and sections of Hindus. Here Hindus includes Jains also. Okay. In the case of scheduled caste people, Jains are not included. Though data suggests that Jains also practice untouchability, but they are not included. See, untouchability is practiced by everyone in different forms. In other religions also there are hierarchies. Pasmanda Muslims, Ashrafs. It is just that the Britishers had to target the largest religion and most people here, so they targeted caste selectively. And it is not that only Brahmins practice untouchability. If you look at anybody with sociology as an optional, you would realize there is a concept called Sanskritization. Yes or no? What is that? That is a direct example of a very good data. In 2012, there was a National Family Health Survey conducted, NCAER, the Council for Applied Economic Research. They conducted a survey on untouchability. More OBCs practice untouchability than other general category people. Of course, Brahmins are the highest amongst Hindus. But more OBCs are practicing untouchability. So, emulating the practices of Brahmins to raise a social status. Direct example exists in society. Maximum cases against atrocities of SCs in UP is against OBCs. Okay, not against Brahmins or other general categories. You have to understand society in depth. So UGC regulations were made randomly, but you have to understand beyond that also what is actually happening in the society. So yes, every group practices. In that survey, even Muslims practice untouchability. Even Christians practice untouchability. I mean, these religions are based on equality. Yes or no? That's their selling point. That join us, there will be no untouchability. But they also do it. Saudi Muslims practice untouchability against Indian Muslims. Indian subcontinent Muslims are not treated at par when they go to these Middle Eastern countries. They are treated as second-grade citizens. That's a reality. So, this kind of situation exists everywhere, sadly. Okay. So, this was Article 25. Next is Article 26. Article 26 is a group right. 25 is for individuals, groups. So, every group has a right to maintain their religious institutions, manage their own affairs in matters of religion. Look at clause C. Property. Individuals have no right to property. Religious groups still have a fundamental right to property. Right to own and acquire property. This was the Keshwan Bharti judgment actually. Keshwan Bharti's temple property was taken by the Kerala regulation of 1969. That is what he challenged. Article 26 was challenged. Are you clear? So, and to administer such property in accordance with law. A group right. Then Article 27, very simple. You will not be forced into paying a jizya. You know jizya? Jizya or jazia as we are now modifying it. Jizya was imposed on whom? Non-Muslims. What's the term for that? In the historical records, Zimmi. They were called Zimmi. Zimmi is a non-Muslim who had to pay some kind of additional tax. And then various writers have mentioned what is the correct way to collect jizya. Jizya was just a way to force people to convert. Because the way to collect jizya was sometimes very, very demeaning. Okay. In fact, some records also claim that jizya should rightfully be collected by also spitting in the hand or the mouth of the person who is giving money. So, how will somebody undergo this kind of behavior every day? So, he has to ultimately convert. That is it. So, what we are saying is, the state will not impose any kind of tax, the benefits of which will be used only to promote Hinduism, Sikhism, that's not allowed. But please understand, if the state is using some part of their tax, some part of total tax collected to provide convenience to a religion, that is not a concern. Don't be a crybaby. That is why state, to give you examples, Kerala, Tamil Nadu, Rajasthan, they are spending 10, 20, 30 lakh rupees every year on Devasthan department. Karnataka, in 2016 budget, they had spent 30 crores on churches. In Gujarat, in Bihar, in West Bengal, Muslim imams are on state's payroll. Out of 4,000 madrasas in Bihar, more than 1,100 are directly on government's payroll. Madrasas are charitable institutions. They impart religious instruction, but government is paying salaries. In UP, they have these spirituality drives. Yes or no? Where the government spends money sending you on Kailash Mansarovar Yatra. MP has this thing where senior citizens are sent to Ajmer Sharif and other places. UP government has spent 394 crores on madrasas. Government spends crores of rupees on improving the Amarnath Yatra route. This is all to provide convenience. So if from the total taxes collected, a small part is spent to provide convenience, that does not violate Article 27. This is a Supreme Court judgment also, Praful Goradia, 2011. Okay. And as far as Hajj subsidy is concerned, it has already been phased out. In 2012, Supreme Court gave a judgment that the government should remove Hajj subsidy in the next 10 years. Clear? What is this Hajj subsidy? It was a subsidy given to Muslims to go on their pilgrimage, Makkah, Medina. But it was not a subsidy for Muslims, it was a subsidy for Air India. Because the airfare was given if you use Air India. Clear? It has been removed now. At the central level, there is no Hajj subsidy. Roughly, records claim that 700 to 800 crores were being given every year. Now that money is spent on educating the minority girl child. Clear? So Hajj subsidy is no longer there. This is Article 27. Just remember this, jizya type behavior not allowed. Okay. And 28 talks about whether educational institutions are allowed to impart religion or not, or religious instruction or not. Again, a clarification, when I am saying religious instruction, don't claim that's a teaching of Prophet Muhammad's life, Guru Nanak's life, Ramayana. That is a moral science class. Difference. When I say instruction, how to perform Havan, how to offer namaz, that is called religious instruction. Teaching on the lives of gods and great men, that is what? Moral science. That is allowed. So, if any school is owned or controlled by the government, state controlled, you cannot impart religious instruction, not allowed at all. If the school is given recognition by the state, accreditation, CBSE, ICSE, all this, then instruction can be allowed, but with parents' consent. If you're under 18, parents' consent. Above 18, your consent. Clear? You can't be forced. But if it is set up by a charitable institution, like, madrasas, for example, their instruction is allowed and you can be forced to attend also. If you don't attend, they can throw you out. Are you clear? 3 categories of religious institutions. Next is 29 and 30. Again, rights meant only for citizens. Any section of citizens residing in the territory of India or any part having distinct language, script or culture shall have the right to conserve the language, script or culture. Clear? This second clause, this is the one which Champakam, that lady, challenged, because it says no citizen shall be denied admission into any state controlled education institution on the grounds of what? Religion, race, caste or language. Madras government order was based on religion and caste. So she was denied admission in a state government college because of her caste. She challenged it on this ground violation only. And Article 13 clause 1 says that no pre-constitutional law can be allowed if it violates fundamental rights. Remember? Yesterday, Article 13. Then we have Article 30, rights of minorities to establish and run their educational institutions. So they have a right to manage their schools and colleges. Most of them are actually linguistic minorities. See, understand, our constitution recognizes two types of recognizes. Recognition is given to religious minorities, yes, and also linguistic minorities. Now, my question is, who is a minority? Definition is not there. It is just that these people are on pan-India basis. And these people are on state basis. That's the only difference. Meaning, you go to Nagaland or Mizoram, Hindus are less than 5% there. Go to other places, 10%, less than 10%. Can Hindus claim minority status in that state? Yes or no? Say something. No, they cannot. Pan-India. Are you less than 50% in India? Yes or no? No, you can't claim the status. Simple. In our country, we have 50% criteria, which is a very stupid kind of criteria. Minority should be a very small number. In most countries, they have a criteria of 5% only, or 10% in some countries. Then some countries follow a simple criteria, like say France. Every religious group which is beyond the Catholic Christian group is considered minority. But most countries follow 5% rule. And that is actually true also. If you think about it, we have 6 categories of minorities. Muslims, then directly Christians. Muslim population is around 14%. Christian is 2.7%. Look at the gap. 2.7 is actually a minority. Definitely. It's a small number. And then you come down to the Sikh people, 1.7, Buddhist people, 0.7, Jains, 0.4, Parsis, 0.006. This makes sense. 14% makes no sense. So we need to rectify that criteria also. It is too high. Because it gives, no, my point is, it gives Muslims disproportionate control amongst minorities. Okay, that is a problem. Other minorities are very small in number. So then the problem is that policies for minorities are always geared towards one minority only. Then in that group, others become minorities. So when I am talking about minorities, I have to focus on the actual minority. That's a small number, right? Imagine 0.4% population of Jains. That's a true minority. Focus on them. Linguistic was on state to state basis. That is why we have around 13 to 14,000 such minority schools and colleges. Exact number is difficult to determine, but few years back in question hour, the government had responded saying that there are 13,555 such schools and colleges. Most of them are run by linguistic minorities. Hindi speaking group here starts a college, Andhra Jyoti, minority education institution. Okay, so most are linguistic minorities because that is possible. Religious becomes very limited. Clear? One more thing, again, right to property. State wants to compulsorily acquire property of an MEI, then the state has to give compensation, and if the property acquired curtails their right to teach, etc., then the property can't be taken away. So in our country, religious groups, minority schools, they have a right to property. Citizens have no right to property, or at least no fundamental right to property. Are you clear? And one more thing, when the state gives any kind of, funds, money, etc., for the benefit of schools and colleges, it should not discriminate against a non-minority school or college or a minority school or college. Funds should be given to everybody equally. Clear? That's about it. Done. Let's come to right to property now, just a passing reference. In our constitution, we had these 3 provisions which were right to property. Look at the first one, 19(1)(f). I think we had mentioned that, to acquire, hold and dispose of property. Then 31(1). this is actually important. The article says, no person shall be deprived of his property save by authority of law. Meaning we can take away your property by making a law. And 31(2) says that the property can be compulsorily acquired, but for only a what? Public purpose. Building a road, bridge, dam, we can take your property. But we'll give you compensation. Don't worry, you'll get some money. Now the article is very weird. It says that, read the last line. No such law be called in question in any court on the ground that the amount is not adequate. Government takes away your entire house and says, take a 5-star, go enjoy. You can't challenge it in the court, right? But don't worry, Supreme Court has interpreted this, saying that no, we can't have an amount like this. The amount should be compensation. They have used the word amount. Amount, any amount. Compensation is a reference to proportionate amount. That is why compensation means equal proportion. You take away my land, I want money which is in the same proportion to the land value. But there is no need to cry so much. Government always overpays. Always overpays when they take land. And it never helps. In Haryana, so many people sold their land to government for projects and all. They got 2, 3, 4 crore rupees. What did they do? Purchased Bolero, Scorpio, etc. Partied, IPL betting. Now they're all poor and jobless. And now they're blaming the government. That they are useless fellows, took away our land, just gave us 3 crores only. The money is gone. What to do now? We should have invested the money in some proper place. FD maybe. If you put 1 crore in fixed deposit also, you will get how much? Around 7 to 8 lakh rupees per annum. That's a salary. Right? So that is why, again, a sociological concept. You have to understand that if you just give people money without any corresponding educational improvement, money and fool are parted soon. Okay. So sadly, that is the case. Anyway, all these provisions create a problem. Land reform. India wanted what? Land reform, redistribution. But when we went to take land from rich people, people went to court claiming Article 19. So government said, okay, let's make a change. And they added these 2 exceptions. That state can make laws to acquire large estate. And such laws can't be questioned on the ground of violation of fundamental rights. And they also created a 31B, 9th schedule. And what was that? If you make any law and put it in the 9th schedule, that law is immune from judicial review. Are we clear on all these things? Okay, no doubt. In 2007, there was an IR Coelho judgment where the Supreme Court said that it's okay, you can make laws and put in the 9th schedule, but every law made after 1973, 24th of April, what is that date? This date is actually the Keshwanan Bharati judgment date. After this judgment date, every law that you have put under Schedule 9 is open to judicial review, but only on one ground: violation of basic structure. It should not violate basic structure. Clear? This is 31B. Now, 31C. Government, see, the point is there is a DPSP called Article 39, which says that the state should take steps to do what? To redistribute country's resources for everybody's benefit and also reduce the concentration of wealth. That's the state's target. So Parliament said, let's do one thing. If our purpose to make a law is to achieve the objective of 39B and C, meaning achieve the objective of reducing the concentration of wealth, achieve the objective of redistribution, then that law should be immune from being declared invalid on the ground of violating 14 or 19. Then zamindars whose land we take away should not run to court claiming that equality is getting violated, my property is getting violated, etc. This has been upheld by the Supreme Court that yes, it is okay. In 1976, government acted over smart, said that no, not only these 2 DPSPs, for any DPSP, most DPSPs are useless. They're very vague in nature. We can't have that. If you make DPSPs above Article 14 and 19, every DPSP, then what is the point of 14 and 19? Remove those articles only. If 14 and 19 can be validated for anything, then there is no point. So that part was removed. This part is valid. Okay. So that's about it. This is just basic information for you. One more 31D was actually added. It has been repealed also. Don't worry. Ignore that. Now when Janata Party came to power, Janata Party said the real problem, all this drama is happening because of right to property as a fundamental right. Let's remove that only. And with this Amendment Act, they removed these two articles and made this article into a constitutional right, something like this. From part 3, it was thrown outside. Okay, so from fundamental right, it became what? Constitutional right. Are you clear? Please mention here. This has been repealed, this has been repealed, and this has become what? 300. All okay? Any problem? No problem? Great. Done. Now finally, the right to enforce these fundamental rights. If your rights are violated, you can directly go to Supreme Court also. So important points. Writs for protection of FR can be issued by both Supreme Court and High Courts. Supreme Court, which article? 32. High Court, which article? 226. Okay, very good. Now, Parliament by, what is bylaw? I had mentioned yesterday also. Bylaw means what? Simple majority. Bylaw means simple majority. So, Parliament by a simple majority can enhance the power of Supreme Court to issue writs. What's the meaning of writ? Writ means directive. Writ means order. The word writ actually means directive or order. So can empower other courts to issue writs. And Parliament, can empower this one. May bylaw empower other courts also to issue writs, and here Parliament can increase the writ power of Supreme Court. Right now, Supreme Court can only issue writs for fundamental right protection. Maybe in future it can be used for legal rights also. Okay. Now there are some special kind of writs that the court issues, which is mentioned here under article. One more thing. Constitutional courts cannot issue writs to each other. Supreme Court cannot issue a writ to High Court. High Court cannot issue a writ to Supreme Court. Are you clear? Court of record cannot issue a writ to other court of record. It is not allowed. It's a Supreme Court judgment, Rupa Hurra, not allowed. Okay, first one, habeas corpus. If at any point of time your right to life is being taken away, police arrests you, keeps you in police custody without any due reason, your family can approach the court, ask the court, please tell them to bring the person in court. The court will order police, bring him here, have the body. And then the court can ask the police, why have you arrested the person? Habeas corpus. Clear? This is how habeas corpus is used. You can use it against public bodies like police or even private individuals. Okay. So very simple way to use this is, the example that I normally quote here is easy to understand. So the example is that, back in the old days, you had the movies of 70s, 80s. The hero in the movie. Hero in that movie was always a complete superstar. Good in studies, great in sports, singer, dancer, teetotaler, never drinks, never smokes. Everything is great. Topper in college. Somehow never gets a job. Always ends up in an ego struggle with the interviewer. But always falls in love with a rich person's daughter. And now he stops the job search and starts singing songs in the park. One fine afternoon, the girl's father is going in his costly car, sees them dancing, very angry, goes home, waiting for the daughter to come. Daughter comes home singing, giggling, dancing, that you do in love, silly things. And he catches the daughter, takes her upstairs, throws her on the bed, closes the door. She falls down the bed, starts crying. Now the hero is outside singing sad songs. That's his problem. If the hero had studied the constitution properly, he could directly go to High Court or Supreme Court, ask them, present the girl. The girl has been held in captivity against her will. Her Article 21 has been deprived. In this case, the court will not ask any question. The court cannot refuse it. It is secured as a matter of right. Meaning, courts can't refuse. The court will not ask you, who are you, what is the problem? No. Immediately the order is issued to the father, bring the girl. Now, in the court, the girl can say, who is this fellow? What is his problem? That is your love and your bond. We can't question all that. So, in future, if you face any problem, the other party has arrested your or kept your supposed boyfriend, girlfriend in custody, or please go use the High Court or Supreme Court thing, but yes, at your own risk. The question should not be who is this fellow, what is his problem, what is her problem. Okay, so you can use this against private and public bodies also. And see, these writs don't have a locus standi. You know locus standi? Locus standi means what? Direct relationship with the matter. If you are personally affected, only then can you go to court. But here it is not required. Any person can go to court. You need not be directly impacted. So there is no locus standi for any of these writs. Clear? Then mandamus means to command. If a public official is not performing their duty properly, you can go to court, ask the court to instruct them to perform duties properly. Now, this is used only for public officials, but it can also be used for private individuals who are performing public function. Okay? You can write here, private individuals performing public function, like maybe a private contractor, government contract, building a road. You can use this writ against them also. Are you clear? Mandamus. But you can't use this writ against president, force him to sign the bill. Not possible. Or legislature, forcing them to make a law. Not possible. Those things are not allowed. Or against your parents, giving you mobile phone. Mandamus, go to court. Don't do all this. You'll get slaps only, no mobile phone. Then, prohibition and certiorari. These are court operated systems. Very simple to understand. If any court takes up a matter which is beyond its authority, the higher court can issue a writ asking it, don't take up the case. How dare you? This is not in your jurisdiction. For example, interpreting fundamental rights. This is a power of High Court and Supreme Court. If some case is filed in lower court, if let's say you file a case in lower court, like this, interpreting fundamental rights, then lower court cannot take up this matter because it is beyond their jurisdiction. If such a case is filed by filed in the lower court, higher court will issue an order against the lower court which is about to commence proceedings in a case over which it has. Clear? High Court will immediately stop the lower court from taking up the case. This is prohibition, to prohibit. What if the lower court judge is also a fool? He takes up the case. He also has very limited knowledge. If the case is accepted, it becomes certiorari. So now lower court has commenced the proceeding. In this case, higher court will have to issue an order that stop the hearing, give me the case, I will hear it. Transfer the case to itself. If the lower court judge was very excited, give a judgment also, then Lower court has concluded what? Verdict. What do? Higher court will cancel the verdict, quash it, and say, give the case to me, I'll decide. Clear? Certiorari and prohibition. Used in the court system only. But just a small point. Since 1991, certiorari is also being used in administrative proceedings. For example, somebody has transferred you. That authority was not the correct authority to transfer you. You can go to the court for certiorari. Clear? So, since 1991, this can be used even for administrative proceedings. But prohibition is only meant for court system right now. Make sense? Confusion? Oh, what is the confusion? You said yes to confusion. Oh, yes to make sense. Okay. Last one, quo warranto. By what authority? Oh, 10:30, just 2 more minutes. Quo warranto. So, quo warranto means what? If any person is holding a public post, the eligibility criteria of which they do not meet, you can go to court and claim it. The court will ask them to prove their criteria. If not, they can be removed. I'll give you a very good example of this. Let's say you waste your time, don't study properly, your attempts are getting wasted, all 6 attempts are over, you are now 32 years old, did not clear UPSC. And you now realize your mistake, that revision, etc., writing answers was important. Your friend comes and says, listen, do one thing, I'll get you a false certificate. OBC, you prepare. Certificate is my guarantee. You now start preparing for the exam. This time you are sincere, you do your best, write, revise every day. You clear the prelims, mains, interview, success. Coaching institutes come to your house, Rajya Sabha TV comes to your house, they ask you tips, you give them all these useless tips that how you studied for so long, etc. Misguiding coming youth also. Anyway, so you give all these, you are celebrating, you are partying, parents are happy, right? Those who have blocked you will unblock you. You are having the time of your life. But neighbors are sad. That's the duty of neighbor, right? To be angry at your success. And neighbor is confused. The neighbor goes to his bank locker, takes out a diary that he has about you. Because neighbors keep a diary. Where is this kid going? At the age of 17, with whom was he going on the bike? They have written everything. He takes out a diary and says that this fellow is now 34. Last year he was 33. How could he clear the exam? He is from this community. Problem. Neighbor now goes to court and files a writ of quorum. Tells the court that I feel this fellow was not eligible. Not that he did not clear the exam. That is secondary. He or she was not eligible to appear for the exam. Please check. The court then issues a writ of quo warranto to you. Show me the certificates. Now, if your friend has done a great job, certificate is very genuine, no problem. Or else, the court finds the certificate false, imposes penalty on you also, and removes you from the post. Clear? This is how it is used. As an example. So, this was quo warranto. Are you clear? That ends our discussion. Couple of other things. As I said earlier also, Article 33, Parliament can modify the application of fundamental rights in their application to certain categories of people. These are examples. I hope you understand the logic. We have to inculcate discipline. Few years back, there was a BSF Jawan who recorded a video of quality of food in the BSF canteen. He was inspired by TikTok generation. He was removed from service because you're not allowed to do all that. He was dismissed from service, actually. Okay? So, example. Clear? Then Article 34 says that in the country, if a martial law, what is martial law? Martial military. If military rule is imposed in the country, then fundamental rights can be suspended in that area. But sadly, we do not know what is meant by military rule because we have never seen a military rule ever in the country so far. We have seen in the pre-independence era, Paka rebellion, Katak, right, 1857, etc. We have seen before independence. not after independence. So we don't know what exactly is going to happen. Ideally, what could happen? This is your state. In that state, a small part of your state, there is complete breakdown of law and order. And the local SP, DM, they are not able to manage it at all. Parliament will make a law and send armed forces to that area. Armed forces will be sent. In this area, then there will be no local government, no DM, no SP, no court, nothing. Military rule completely. Armed forces will restore law and order, hand over back to administration and leave. That's the thing. Are we clear? But again, this is just an example because we don't know what exactly can happen. Okay. And lastly, Article 35. There are certain things for which laws can be made only by Parliament. For example, providing residence as a condition for employment. Who can make a law? Only Parliament, not the states. Or empowering other courts to issue writs. Who can make a law? Parliament. Or what is this? Modifying the rights for other people. Or imposing martial law. Or providing punishment for untouchability. States cannot make a law for this. Only center can make a law. So we have a law, right? For untouchability punishment. What is that law called? PCRA, Protection of Civil Rights Act. And Traffic in Human Beings and Forced Labor, like Bonded Labor System Abolition Act. Okay. That's it. This ends our discussion on fundamental rights. You can go through it. Rights are available against state, some against people. They are negative obligations, some are positive also. Like Article 21A is a positive obligation. Some right, one minute. Some rights are self-executory. They can be used on their own. Some rights require laws. Rights are justiciable, means what? Enforcement in courts. Rights are not absolute. Restriction can be imposed. Some rights meant only for citizens. Which rights? Great. Rights can be suspended during emergency. Rights are amendable. Yes or no? And they can be modified in their application to special services by law. Which article is that? 33. Tomorrow we'll continue by solving some questions, DPSP, duties, etc. Please come at 7:30. Don't change timings until I say so. Okay? That's all for me. Jai Hind.